My name is Pearl Thibodeau. I am 46 years old. On a Saturday morning in August, 3 years ago, I drove from my apartment in New Orleans to my grandmother's house in Opelousas, Louisiana, and I found the locks changed. I want to describe this moment specifically because I think the specificity matters more than the general shape of it. The house was a double shotgun on Bienville Street that my grandmother's family had owned since 1923. The specific old-style Louisiana house with the narrow facade and the rooms that ran one behind the other like train cars, built from cypress wood and raised on brick piers that kept the floors dry through 100 years of South Louisiana water. I had driven the 2 hours from New Orleans that morning because my grandmother, Odette Marie Fontenot, had died the previous Tuesday, and the family was gathering over the weekend to begin the process of settling her affairs. And because Odette had told me, 3 months before she died, that there was something in the house I needed to find. She said this to me on a Sunday afternoon in May, sitting in the front room of the Bienville Street house, in the specific cane-back chair she had occupied for the 38 years she had been its primary occupant, with the afternoon light coming through the front window and the sound of the neighborhood visible through the screen door. She was 87 years old, and she had the particular quality of someone who understands that the time remaining is specific rather than general, who has moved from the abstract knowledge of mortality to the particular knowledge of this specific time and these specific people and these specific things that need to be done before the time ends. She said, "Pearl, there is a box in the cedar chest in the back bedroom, the cedar chest my mother brought from Broussard when she married. You know which one?" I said, "Yes." She said, "In the box there is an envelope. In the envelope there are papers. You need to have those papers before anything else happens with this house." I said, "Grand-mère, what kind of papers?" She said, "The kind that answer a question before it gets asked too loud." She said this in the specific way she said things that were important, which was with the particular quality of understatement that Louisiana Creole women of her generation used when they wanted to communicate something significant, without making a production of the significance. I said, "Are you worried about the house?" She said, "I am not worried. I am practical. Your great-aunts Lucy and Marguerite have been watching this house for 40 years, waiting for me to die so they can claim it. I have known this since before you were born. I have made sure they cannot. The papers in the box are how I made sure." She said, "Get the papers before the family descends. That is all I am telling you. She died in July, not May, as I had expected from the urgency of her instruction, which gave me 2 months in which I did not get the papers, because I kept telling myself I had time, and because the specific conversation required to go into my grandmother's cedar chest and remove documents while she was still alive was a conversation I did not know how to have with the directness it required. I am telling you this because I think the honesty is important. My grandmother told me to get the papers. I did not get the papers before she died. This was a failure of follow-through on my part that created the specific situation I am about to describe, and I want to say so plainly rather than constructing a narrative in which I was entirely prepared for everything that happened. She died on a Tuesday. By Thursday, my great-aunts Lucy and Marguerite had driven from Baton Rouge and Lafayette respectively and had taken up residence in the house on Bienville Street. By Friday, they had called a locksmith. By Saturday morning when I arrived, the locks were changed and Lucy was standing on the front porch with the specific quality of a woman who has been waiting for an argument and who is ready for it. I said, "Lucy, I need to get something from the house." She said, "The house is in the estate. Nothing leaves until the estate is settled." I said, "I need to get something from the cedar chest in the back bedroom." Grand-mère told me to get it. She said, "Odette is gone. What she told you does not change what the law says, and the law says this house is part of the estate." I said, "You changed the locks the day after she died." She said, "We are protecting the estate." I said, "From whom?" She said nothing. I said, "Lucy, I am going to tell you something directly, because I think you deserve to hear it directly. Grand-mère told me there were documents in the cedar chest that are relevant to the house. She told me to get them before the family descended. I did not do that when she was alive because I thought I had time. I am asking you to let me into the house to retrieve those documents. She said, if there are documents relevant to the estate, they can be reviewed by the estate attorney. I said, the estate attorney represents the estate. The documents I am describing may be relevant to whether the house is part of the estate at all. She looked at me. She said, the house is part of the estate. Odette had no will. I said, Grand-mère had no will that you know about. She said, there is no will. We have confirmed this. I said, I am not talking about a will. She said, then what are you talking about? I said, let me into the house and I will show you. She did not let me into the house. I called my attorney from the car in front of the Bienville Street house, and I explained what I knew, and what I suspected, and what I needed, and she told me to come to her office on Monday, and to bring whatever documentation I had, and to be patient across the weekend, because there was nothing legally actionable until Monday. I drove back to New Orleans. I was not patient across the weekend, though I was legally quiet across it. The distinction is specific, and I want to make it clearly. I did not do anything that weekend that could be characterized as improper or that created any legal difficulty for the subsequent proceedings. I was also not at peace. Before I tell you what happened on Monday and what was in the cedar chest when I finally reached it, let me take you back to the beginning. Because the beginning is where the specific shape of everything that followed was established, and because the beginning is where I first understood what my grandmother had done and how long she had been doing it and what kind of woman she was to have been doing it with such patience for such a long time. I grew up in Lafayette, Louisiana, the younger of two daughters born to Celestine and Raymond Thibodeau, who were my grandmother Odette's son Raymond and his wife, a woman from Breaux Bridge named Celestine Moe, who had the particular warm practicality of someone raised in a family that managed a rice farm, and who brought that practicality to everything she did, including raising two daughters in the specific way of people who believed that competence was the most useful thing you could give a child. My father was a pipe fitter who spent his working life at the chemical plants along the river west of Baton Rouge, the specific blue-collar professional world of industrial South Louisiana, that required both technical competence and the particular endurance of people who worked long hours in difficult conditions and who built their lives from the specific wages that work produced. He was a good man in the particular quiet way of good men, who do not require recognition for their goodness, and who express care through presence and reliability rather than through dramatic gesture. My mother managed the household and eventually returned to work part-time when my older sister Celeste and I were both in school, taking a position as a bookkeeper for a small construction company in Lafayette, where she worked for 14 years, and where she built the specific reputation of someone who was completely reliable and completely accurate, and whom the owner of the company described when she retired as irreplaceable, which he meant as a compliment, and which she received as one. My grandmother Odette was the specific center of my childhood, in the way that certain grandparents become the center of a grandchild's childhood, not through any formal arrangement, but through the particular magnetic pull of a person who is genuinely interested in children as people, rather than as objects of care. She lived 2 hours away in Opelousas, which meant I did not see her daily, but when I saw her, the seeing had the particular complete quality of someone who was fully present in the time we shared. She cooked. I want to say this first because cooking was the specific language she used to transmit everything she thought was worth transmitting, and the transmission through cooking is the reason I know things about the Thibodeau family history and the Fontenot family history, and the specific accumulated knowledge of a woman who had been born in 1931 and had lived through every decade of the 20th century and into the 21st, and had paid attention across all of it. She made filet gumbo the specific way that Opelousas gumbo is made, which is different from the gumbo of other parts of Louisiana in specific ways that matter to the people who know gumbo from the inside. She made pain perdue from the bread that was a day old and the eggs from the chickens she kept in the back of the property until she was 82, and the particular vanilla that she ordered from a woman in New Iberia who had been making it the same way since 1965. She made couscous on Sunday mornings, the cornmeal dish of Louisiana Creole breakfast that most people outside South Louisiana have never encountered, and that I make every Sunday now in my apartment in New Orleans, because it is the specific thing that tastes like her. She also talked while she cooked. This was the particular gift of cooking as a transmission mechanism. The attention required for the cooking created the specific kind of ambient conversation where things were said that might not be said in the formal context of a conversation organized around saying them. She talked about her mother and her father and the house on Bienville Street and what the house had meant to the family across the decades and the specific history of how it had come to be the Fontenot house and what that history meant for who the house belonged to now. She was careful in how she talked about Lucy and Marguerite. Not dishonest, careful. She did not say unkind things about them in my presence when I was a child, which I understand now as a specific, deliberate decision by someone who understood that a child's relationship with her great aunts should not be shaped by an adult's assessment of those great aunts. What she said about Lucy and Marguerite was factual and measured. They were her husband's sisters. They had grown up in a different household with a different understanding of what the Fontenot family history meant, and they had their own view of what should happen with the house that was not her view, but that she understood as coming from the specific place it came from. I understood from this careful, measured language that something was contested between my grandmother and her sisters-in-law, and that my grandmother had a specific position on the contest that she had decided not to express in front of her grandchildren. This is the particular communication of an adult who wants a child to know something important without saying it directly, and I received it in the specific way that children receive such communication, which is as a signal that there is something to know without the specific content of the knowing. The content of the knowing arrived when I was 12 years old, on a Saturday morning when I was at the Bienville Street house helping my grandmother in the kitchen, and when she said, in the specific conversational aside of someone mentioning something that has come to her mind while doing something else. Your great-aunt Lucy called yesterday and said she was planning to visit in August. To see the house. I said, doesn't she visit sometimes anyway? She said, she visits. She also assesses. There is a difference. I said, what is she assessing? She said, whether things are being maintained properly, whether the house is being taken care of in the way it deserves. I said, is it? She said, this house has never been in better condition in its 100-year history than it is right now because I have been taking care of it for 38 years, and I know what it needs. The assessment Lucy is doing is not about the condition of the house. It is about who is in the house, which is me, which she believes should not be me. I said, why does she believe that? She said, because she is Alphonse's sister and she believes that what Alphonse built should belong to Alphonse's family, not Alphonse's widow. My grandfather Alphonse had died in 1984, 4 years before this conversation. He had died of a stroke at 61, and the dying had been the particular sudden kind that doesn't permit goodbyes. My grandmother had been in the house on Bienville Street for 35 years when he died, and had remained in it for the 33 years since, with the particular steady presence of someone who understood the house as the primary geographic expression of her life, and who was not going to leave it because someone else had a different understanding of who it belonged to. I said, does Aunt Lucy have a legal claim to the house? She said, she has an opinion about the house. Whether she has a legal claim depends on a document that Alphonse's mother signed in 1949. Which I have. I said, what is the document? She said, a deed of gift. Alphonse's mother gave this house to Alphonse and to me, as a married couple, in 1949. Not to the Fontenot family, to Alphonse and Odette, which means that when Alphonse died, his half came to me. The house belongs to me entirely. Lucy's opinion about what Alphonse built is not the same as a legal claim, and the deed of gift is why. I said, "Does Lucy know about the deed?" She said, "Lucy knows that Alphonse's mother gave us the house. She does not know the specific legal form of the giving, and I have not corrected her misunderstanding because correcting it would give her time to find arguments against it. When the time comes for the argument, I want the document to speak." I was 12 years old, and I understood something specific about my grandmother in that moment that I had not understood before, which was that she had been having a long, patient conversation with a document in a cedar chest about a house on Bienville Street, and that she was going to let the conversation conclude in its own time, and she was not going to rush it. She was 59 when she said this to me. She was 87 when she died. She waited 28 more years. I want to tell you about the specific history of the house on Bienville Street before I tell you about the Monday after the locked doors, because understanding what the house was and what it represented to the different people who had claims on it, or believed they had claims on it, is necessary to understanding why the deed of gift in the cedar chest mattered as much as it did. The house was built in 1923 by Alphonse's father, Edgar Fontenot, who had been a carpenter and a bricklayer, and who had spent 20 years building other people's houses in Opelousas before he built his own. He built it from cypress that he selected himself, the old-growth cypress that was still available in the early 1920s from the mills that were working through the last of the great Louisiana cypress forests, and he built it with the particular attention to quality that someone who has spent 20 years building houses develops when he is finally building his own. The house had 4 rooms in the double shotgun arrangement, 2 rooms on each side connected by a central wall with doors between them, the specific design that allowed extended families to share a structure while maintaining separate households. Edgar and his wife Celeste lived in the left side. Their children, including Alphonse and his sisters Lucy and Marguerite and 2 brothers, who had both died before the house became contested, used the right side. Edgar died in 1948. Celeste, his widow, was 71 years old and had the particular practical intelligence of a woman who had been married to a carpenter for 42 years and who understood what structures required to last. She understood in 1949 that the house needed someone specific to be responsible for it, and that the someone specific needed to be identified while she was still alive to identify them. She identified Alphonse and Odette. The specific form of the identification was a deed of gift, the Louisiana legal instrument that allowed property to be transferred between family members for nominal consideration, executed in the notary's office of a man named Marcel Bourgeois on Commerce Street in Opelousas on a Thursday afternoon in March of 1949. The deed transferred the property at 412 Bienville Street from Celeste Fontenot to her son Alphonse Fontenot and his wife, Odette Fontenot, née Thibodeau, as joint tenants with right of survivorship for the consideration of $1 and the promise to maintain the property in good repair. The deed was signed by Celeste, witnessed by 2 neighbors whose signatures were legible, and notarized by Marcel Bourgeois with the particular official stamp of a Louisiana notary public, which carries in Louisiana the specific legal weight of a judicial officer, because Louisiana's notarial system derives from the French civil law tradition, in which notaries have a status that common law states do not recognize. The deed was recorded with the St. Landry Parish Clerk of Court's office on the following Monday. I know all of this because my grandmother told me across the years of my childhood, in the specific installment method she used for important information, adding detail in each subsequent telling as I became capable of receiving more detail. By the time I was 20, I knew the specific story of the deed of gift with enough accuracy that I could have described it without the document. But I did not have the document, which is the specific difference that mattered. My grandmother had the document. She had it in the cedar chest in the back bedroom of the Bienville Street house, in the envelope she described to me in May with the specific other papers she had assembled across the years that supported and confirmed and contextually elaborated the deed's central fact, which was that the house had been given to Alphonse and Odette as joint tenants with right of survivorship, which meant that when Alphonse died, his interest in the property passed automatically to Odette, and the house was hers entirely. Lucy and Marguerite had watched their sister-in-law live in the house on Bienville Street for 33 years after Alphonse died. They had watched her maintain it and tend the garden and replace the roof in 1991 and update the plumbing in 2003 and have the cypress exterior treated against moisture in 2009. They had visited it and eaten in its kitchen and sat on its front porch and watched it be exactly what it had been in 1923, a specific well-maintained house on a residential street in Opelousas that was worth, at the time of my grandmother's death, approximately $240,000. They believed, and had believed since Alphonse's death in 1984, that the house should have come to the Fontenot family rather than remaining with Odette, and the specific basis of this belief was their understanding of what their mother Celeste had intended in 1949, which was not a transfer of property to Alphonse's wife, but a transfer of stewardship to Alphonse, with the understanding that the house would remain in the Fontenot line. Their understanding was not the deed. The deed said what it said. But they did not know the specific legal form of what Celeste had done, and my grandmother, in the specific patient way that had characterized her relationship to this particular contest for 40 years, had not corrected their misunderstanding. She had waited for the document to speak. My attorney's name was Catherine Broussard. She had practiced real estate and estate law in New Orleans for 24 years, the specific combination of expertise that the situation required, and she had the particular direct manner of someone who has spent 24 years dealing with the specific human difficulty of family property disputes in Louisiana, and who has learned that directness is usually kinder than its alternatives. I was in her office at 9 on Monday morning. I told her everything I knew, which was the story of the deed of gift, and the cedar chest and the locked doors and my grandmother's instruction in May. I told her what my grandmother had said about waiting for the document to speak. I told her what Lucy had said on the front porch on Saturday. Catherine listened to all of it with the specific focused attention of someone who is simultaneously receiving information and organizing it into a legal framework. When I finished, she said, "The deed of gift, if it exists and if it says what you've described, is the dispositive document in this situation." I said, "Dispositive meaning it settles the question." She said, "Meaning that if the house was transferred to your grandmother and grandfather as joint tenants with right of survivorship in 1949, and if your grandfather died in 1984, then your grandmother became the sole owner of the property at the time of his death by operation of law, without any further action required. And if your grandmother died without a will, as your great-aunts have claimed, then the property passes under Louisiana intestate succession laws to her heirs." I said, "Her heirs being?" She said, "Her children and their descendants." "Which would include your father as one of her children, and you as your father's child if your father has predeceased her, and your sister." I said, "My father died in 2019. She said, "Then you and your sister are your father's heirs, and therefore your grandmother's heirs for his share." She said, "The deed needs to be found and authenticated. Once we have the deed, the legal picture becomes clear. Without the deed, the situation is more complex because your great-aunts can claim that the original transfer was not what you describe." I said, "How do we get into the house?" She said, "We petition the court for an emergency order allowing access to the property for the purpose of retrieving documentation relevant to the determination of the estate. Your great-aunts have changed the locks and are preventing access to property that is not clearly theirs to control. That is a specific legal problem I can address quickly." She filed the petition Monday afternoon. The hearing was Wednesday morning. I want to tell you about the Wednesday morning hearing because it is the specific moment when my great-aunt's understanding of their position encountered the specific limitations of that understanding, and because the encounter has a particular quality that I think is worth describing accurately. Judge Elaine Thoreau had been on the St. Landry Parish bench for 11 years and had the specific quality of a judge who has heard many family property disputes and who has developed through that experience a particular calibrated skepticism about the claims all parties make in the heat of such disputes. She was in her mid-50s, methodical and specific in her questions. Lucy and Marguerite had retained an attorney, a man named Gerald Fontenot, no relation to our family as far as any of us knew, who had been practicing in Opelousas for 16 years and who had the particular self-assurance of someone who handles a significant number of estate matters in a small parish and who expects to be able to manage the situation he has been retained to manage. He presented the position of his clients that the house on Bienville Street was the rightful property of the Fontenot family, that Odette had died without a will, that the estate should be administered under Louisiana intestate succession laws, and that my great-aunts, as sisters of the deceased Alphonse Fontenot, who was the house's rightful owner, had an interest in the estate that entitled them to participate in its administration, including securing the property against unauthorized access and removal of items. He said this with the particular confident precision of someone who believes he has the facts on his side. Catherine Broussard then addressed the court. She said, "Your Honor, the premise of opposing counsel's position is that the house at 412 Bienville Street was the property of Alphonse Fontenot at the time of his death in 1984. My client contends that this premise is incorrect. The house was transferred in 1949 to Alphonse Fontenot and his wife Odette Fontenot as joint tenants with right of survivorship. Upon Alphonse's death, his interest passed automatically to Odette. The house has been Odette's sole property since 1984. My client has reason to believe that the original deed of gift from 1949 is located in a cedar chest in the back bedroom of the property. The purpose of our emergency petition is to allow access to the property to retrieve that document." Gerald Fontenot stood immediately. He said, "Your Honor, opposing counsel is describing a document that has not been produced. We have no evidence that this deed of gift exists." Judge Thoreau said, "Counsel, that is precisely why the petitioner is asking for access to retrieve it. If the document exists, its retrieval resolves the question. If it does not exist, the petitioner's position is considerably weaker. In either case, the document's existence or non-existence is determinative, and preventing access to the location where the document is allegedly located serves no legitimate purpose, and potentially serves an illegitimate one." She looked at Gerald Fontenot. She said, "Your clients changed the locks on a property before the ownership of that property has been legally determined. Can you explain the basis for that action?" Gerald Fontenot said, "Your Honor, my clients were protecting the estate from potential dissipation." She said, "From whom?" He said, "From individuals who might remove items of value from the property." She said, "Are you suggesting that the petitioner in this case planned to remove items of value illegitimately?" He said, "I am suggesting that absent clear legal authority, my clients felt it necessary to secure the property." She said, "Absent clear legal authority is the precise description of your client's situation at the time they changed the locks. They also lacked clear legal authority at that point. Does your argument apply equally to them?" He said nothing for a moment. She said, "I'm granting the emergency petition. The petitioner and her attorney will have access to the property Wednesday afternoon for the purpose of retrieving the cedar chest and its contents. The parish marshal will be present. A representative of your clients may also be present. The chest and its contents will be transported to the clerk of court's office for preservation pending resolution of the estate matter. Parties will reconvene Thursday morning to review whatever the chest contains." The Wednesday afternoon access took approximately 40 minutes. Lucy was there. Marguerite was not. Gerald Fontenot was there. The parish marshal was there. Catherine Broussard was there. I was there. The cedar chest was where my grandmother had told me it would be, in the back bedroom against the south wall, the specific piece of furniture that I recognized from every visit to the Bienville Street house across my entire life. The chest that my grandmother's mother had brought from Broussard when she married, and that had come with my grandmother when she married Alphonse, and that had been in this specific room for 60 years. It smelled, when Catherine opened it with the marshal's supervision, of cedar and of something older underneath the cedar, the particular smell of things that have been kept carefully for a very long time. The chest contained linens and a quilt and a tin box, and underneath the tin box an envelope. Catherine removed the envelope carefully, wearing gloves she had brought for exactly this purpose, and held it up so that the marshal and Gerald Fontenot could see it, and then placed it in a document preservation bag she had brought, also for exactly this purpose. The envelope was sealed. It would be opened Thursday morning in the clerk's office. Lucy watched all of this from the doorway of the room. She watched the chest being opened and the envelope being found and placed in the preservation bag. Her expression was the specific expression of someone who has been certain of something for a long time and who is encountering, for the first time, the possibility that what she has been certain of is not what she thought. She did not say anything. I looked at her. I did not say anything either. Thursday morning at the St. Landry Parish Clerk of Court's office. Judge Turode was not present for this portion. The clerk's office handled the opening of the envelope with both parties' attorneys present and the contents documented and copied before being distributed to the parties. The envelope contained 3 documents. The first was the deed of gift, the original, signed by Céleste Fontenot on a Thursday afternoon in March of 1949 in the office of Marcel Bourgeois Notary, with the 2 neighbors' witnessing signatures and the notarial stamp clearly legible. The transfer was to Alphonse Fontenot and his wife Odette Thibaudeau Fontenot as joint tenants with right of survivorship for the consideration of $1. The deed bore the St. Landry Parish Clerk of Court's recording stamp from the following Monday. The second was a handwritten note from my grandmother, undated, that I will describe rather than reproduce because it belongs to her and to our family, rather than to this story. It was addressed to me by name. It explained the deed and what it meant, and what she had been waiting for and why she had waited. It said certain things about the house and about Lucy and Marguerite that were specific and measured in the way all of her observations were specific and measured, and it said certain things about me and about what she hoped the house would be for me that I will carry for the rest of my life. The third document was a letter from Marcel Bourgeois, dated 1961, the year before he died, written to my grandmother, confirming the deed's execution, and noting that a copy had been retained in his notarial records, and that the original was in her possession. He wrote that he had prepared the document at Céleste's specific request, and that Céleste had been clear about the joint tenancy with right of survivorship designation and what it meant, and that she had understood and intended exactly what the document said. Catherine Broussard placed all 3 documents in the preservation bag with the others. She turned to Gerald Fontenot. She said, "I believe the evidentiary picture is now somewhat clearer." Gerald Fontenot looked at the documents for a long moment. Then he looked at Lucy, who had come to the clerk's office for the opening. He said, "I'll need to consult with my clients." Lucy said, "Gerald." He looked at her. She said, she knew. She always knew. She was waiting. He said, "Lucy," she said, 60 years. She had that paper for 60 years, and she let us think what we thought, and she waited. He said, "We need to consult." She said, "There's nothing to consult. The paper says what it says." She looked at me then. The specific quality of that look is something I want to describe. because I think it is the most important moment in the courtroom portion of this story. Not the most important moment in the story, which came later, but the most important moment in the formal legal portion. She said, "Your grandmother. She is more like me than I thought." I said, "What do you mean?" She said, "Patient. She was patient. I have been patient for 60 years waiting for a claim to this house." She was patient for 60 years with a paper in a box that would have ended the waiting at any time. We were both waiting. I did not know we were both waiting for the same thing. I sat with this for a moment. I said, "She waited until it was needed." Lucy said, "Yes." She said, "It was needed." The legal proceedings took 4 months after the discovery of the deed. Gerald Fontenot advised his clients not to contest the deed's validity, which was the specific correct advice given the quality of the document and its recording in the parish records. And Lucy and Marguerite accepted the advice with the particular quiet of people who have run out of arguments. The estate was settled in December. The house on Bienville Street passed to me and my sister Celeste, as my grandmother's heirs, with the specific share that Louisiana intestate succession law provides for grandchildren when the relevant child has predeceased the grandparent. My sister Celeste lives in Houston. She has 3 children and a husband, and the particular full life of someone who has organized her adulthood around a family she built rather than the family she came from, which is a legitimate and specific choice that she made deliberately. She agreed when the estate was settled that I should be the one to live in the house, that she would take her share in another form rather than requiring a sale, which was the specific generosity of a sister who understood both what the house meant to me and what the selling of it would have meant. I moved to Opelousas in January of that year. Not immediately into the house, because the house required specific work before it was habitable in the particular way I intended to inhabit it, the work of someone who is not merely occupying a house, but who is taking up the specific responsibility for a house that was built in 1923 and that has been maintained across 100 years by people who understood what maintaining it required. I spent 3 months on the work. I hired a contractor who specialized in historic structures, a woman named Patrice who had been restoring old houses in St. Landry Parish for 20 years and who walked through the Bienville Street house the first time with the specific practiced attention of someone reading a building's structural history, placing her hands on the cypress walls and listening to the floors and examining the brick piers and the foundation, and eventually saying, "This house is sound." Whoever took care of it knew what they were doing. I said, "My grandmother took care of it for 60 years. She said she did it right." I moved in April. I am writing this from the front room of the house on Bienville Street, in the specific cane-back chair that was my grandmother's, with the afternoon light coming through the front window exactly as it did when she sat in this chair and told me, at 12 years old, that she had a deed in a cedar chest and that she was waiting for the document to speak. I want to tell you about the specific conversation I had with Lucy 4 months after I moved in, because this story has a part that happens after the legal proceedings, and that matters as much as anything that happened in the clerk's office or before the judge. Lucy called me on a Sunday afternoon in late summer. I was in the kitchen making cooch, which is what I make on Sunday mornings and sometimes on Sunday afternoons, because the making of it is itself a form of presence with my grandmother regardless of the day. She called while the cornmeal was in the iron skillet, and I answered with one hand and stirred with the other. She said, "Pearl." I said, "Lucy." She said, "I am calling because I said to myself that I would call when I was ready, and I believe I am ready." I said, "All right." She said, "I want to say something about what happened with the house and about what I did when Odette died. I want to say it simply." I said, "Say it." She said, "I was wrong to change the locks. I was wrong to claim a right to the house. that the law and the document showed I did not have. I knew, when I saw the deed, that I had been wrong about the basis of my claim. The claim I believed I had was not the claim that existed. She said, "I am saying this to you directly because you deserve to hear it directly." I said, "Thank you for saying it that way." She said, "Your grandmother." She never said anything. Not once in 60 years did she tell me directly that she had the paper and that the paper settled the question. She could have. She let me believe what I believed. I said, "Yes." She said, "Do you know why?" I said, "I know what she told me." She said she was waiting for the document to speak, rather than for her to speak it. She said if she told you about the deed, you would find arguments against it, and the time and energy of those arguments would be wasted on something that the document would eventually resolve. Lucy was quiet for a moment. She said, "She was right." I said, "She usually was." She said, "She was also protecting something else, not just from the argument." I said, "What do you think she was protecting?" She said, "The relationship." If she had produced that paper in 1984 when Alphonse died and said, "Here is why the house is mine and not yours," we would have had the argument then. And the argument would have been a different kind, not legal, personal, the kind that ends things between people. She said, by waiting, she let 60 years go by. 60 years of visits and dinners and the specific ordinary contact of family. That would not have happened if she had produced the paper in 1984. I sat with this for a long time. I said, "She kept the relationship alive at the cost of your certainty about the house." Lucy said, "And at the cost of what I would have done with that certainty, which was nothing. I had no legal basis for a claim. I had only the belief that I had one, and she let me have the belief." I said that was generous. She said it was specific. She knew what she was doing. I said yes, she always knew what she was doing. Lucy said, "Pearl." I said yes. She said, "The house." She left it to the right person. I said, "She thought so." She said, "I think so too." Now, she said, "I hope you will let me visit when I am in Opelousas." I said, "The door is open, Lucy." I meant it specifically. The door of the house on Bienville Street, which had been locked against me in August of 3 years ago, and which was now mine to open or close as I chose, is open to her. She has come twice since that call. She sits in the front room in the afternoon light and she looks at the walls, and she does not say very much, but the quality of her presence is different from anything I would have expected from her before the call. The particular quality of someone who has arrived somewhere she was not certain she would be allowed to arrive, and who is receiving the arrival with the full gratitude it deserves. The cedar chest is in the back bedroom where it has always been. The envelope with the deed of gift and my grandmother's note and Marcel Bourgeois' letter is in the cedar chest. Return to it after the legal proceedings concluded, because that is where my grandmother kept it, and where I believe it belongs. I have read my grandmother's note many times. I will not tell you everything it says because what it says to me is private in the specific way that a letter from a grandmother to her granddaughter is private. I will tell you one thing it says because I believe she intended it to be said to more than me. She wrote, "Pearl, the things that are truly yours do not need to be announced or argued or fought for. They need only to be documented and protected and patient. The paper was always here. The house was always mine. I spent 60 years being responsible for it, and the 60 years speak as loudly as any document. But the document was necessary. When the patience runs out and the voices get loud, the document is what speaks clearly and cannot be argued with. Keep the documents. Keep the patience. They are the same thing in the end. She was right. She was usually right." The house on Bienville Street is 101 years old. The cypress wood Edgard Fontenot selected from the mill is as sound as it was in 1923. The morning light comes through the kitchen window at the specific angle of a South Louisiana morning, that is warm and specific and particular to this place and this house and this time of day. And I make couscous in the kitchen on Sunday mornings, and the making of it is itself a form of presence with her and with her mother and with Celeste, who brought the cedar chest from Broussard when she married, and with Edgard, who built the house, and who understood that old-growth cypress would outlast everyone who would ever live in it. He was right, too. Here is what a deed of gift kept in a cedar chest for 73 years, and a grandmother who was patient in the particular way of someone who understood that patience was the most powerful available response to a specific kind of injustice taught me. I know that the specific legal form of how property is given matters more than the intention behind the giving, and that understanding this distinction in advance is the particular form of protection available to people who understand the law, and that my grandmother understood it and acted on it in 1949, when she and Alphonse received the deed of gift that specified joint tenancy with right of survivorship, which is the specific language that determined what happened when Alphonse died, and which my great-aunts did not know was in the document. I know that the patience my grandmother chose, the 60 years of allowing Lucy and Marguerite to maintain their belief in a claim they did not legally have, was not weakness or avoidance, but the specific calculation of someone who understood that there were multiple things she was protecting simultaneously: the house, the legal record, and the relationships within the family, and that not all three could be protected through the same action at the same time, and that her choice of which to protect actively and which to let be was made with the full consideration that a woman who had been thinking about something for 60 years can bring to it. I know that the document spoke when it needed to speak. My grandmother said that documents speak when they are needed, and that the waiting for the needed moment is the work. The needed moment arrived when Lucy and Marguerite changed the locks the day after my grandmother died, which produced the specific legal proceeding that required the document to be produced, which allowed the document to say what it had always said, which was that the house was Odette's. The document did not need to speak before that moment, because before that moment the house was Odette's in practice as well as in law, and the speaking would have been at the cost of the relationships rather than in service of the truth. And I know that the house on Bienville Street, which Edgard Fontenot built in 1923, and which Celeste Fontenot gave to Alphonse and Odette in 1949, and which Odette maintained for 60 years, and which came to me and my sister after she died, is the specific physical expression of 100 years of a family's commitment to a particular place and a particular quality of care. The house deserves to be maintained, and it is being maintained, and the specific work of its maintenance is also the specific work of being in relation to everyone who maintained it before me, which is the particular form of stewardship that a house of this age and this history requires from the person who is responsible for it now. I am responsible for it now. I understand what this means. I was taught by someone who understood it for 60 years and who left me, in an envelope in a cedar chest that smells of cedar and something older, the specific documentary proof that it was always mine, alongside the note that told me why and what to do with it. The door is open. That is what she left me in the end. That is my story. A cedar chest in a back bedroom. A deed of gift from 1949 that a woman kept for 73 years and waited for the right moment to produce. Locked doors on a Saturday morning, and a front room on Bienville Street where the afternoon light comes through the window in the specific way of a South Louisiana afternoon, warm and gold and particular to this house and this chair, and the specific ongoing presence of everyone who has ever sat in it. If this reminded you of something someone kept safe for you until the keeping was over and the having began, I want to hear from you. Drop it in the comments. Share this with someone who needs to know that the most important documents are sometimes the ones held longest in the quietest places, waiting for the moment when their speaking matters more than anything else. Hit subscribe, and I will see you in the next one.